Good morning and welcome to the Judicial Committee of the Privy Council. Because of the COVID pandemic, we continue to sit remotely but look forward to returning to the courtroom itself soon. Today we are hearing an appeal from the Republic of Mauritius on a question of land law and acquisitive prescription, in which the first respondent, the late Mr. Ramsawhook, claims to have acquired ownership of a piece of land by peaceable occupation for the prescriptive period of 30 years. The appellant, Mrs. Hurhangee, challenges the decision of the Mauritian courts which upheld Mr. Ramsawhook's claim. Today, Mrs. Hurhangee is represented by Mr. Nankishore Rambert, Senior Counsel, and Shahina Karim, and the family of Mr. Ramsawhook by Bertrand Chung. Before inviting Mr. Rambert to begin his submissions, I will introduce the court. I am Lord Hodge, and sitting with me today are Lord Kitchen.
Good morning.
Lord Sales.
Good morning.
Lord Hamlin.
Good morning.
And Lord Burrows.
Good morning.
I now invite you, Mr. Rambert, to begin your submissions.
Yes, my lord. Morning, my lords. My lords, the central issue, which will, of course, be the subject matter of this appeal, would be the occupation, the nature and quality of the occupation of the late respondent number 1. Whether the respondents occupied the land of the appellant with all the requisites which are required to satisfy the law under Article 2229. I hasten to add, I am sure your lordships would have gone through the Supreme Court judgment at page 423 and the Court of Civil Appeal at page 782. And I'm sure it must have dawned upon your lordship that there is one thing fundamental which is lacking in both judgments. That is the analysis in law of the occupation by the respondent number 1. It will be my task to demonstrate to your lordships that in the present matter there are legal requirements which are not satisfied, or to say the least, lacking. And this analysis, neither the Supreme Court nor the Court of Civil Appeal did embark to see the effect of the evidence on record and the application of the law on this issue. My lord, I believe in a nutshell, the evidence before the courts in Mauritius were as follows. That is, the appellant stated that since about 1975, when her father gave her the land, and she has occupied same through her father initially until about 1989, and thereafter, when he was bedridden, it was her husband who was looking at the land, after the land, till about 1990, when unfortunately there were matrimonial issues, and they which ended up in a divorce actually, and she stopped caring and looking after the land, and that any possession by the respondents of her land could only have occurred after 1990. On the other hand, having set out this, she brought in one specific witness, Mr. Ranoa, to support her version. That version, my lord, may I hasten to add, you would have seen in the judgment of the Supreme Court, is alluded to by the learned judge, but then he makes no finding of whether he believes that witness, he doesn't believe that witness, save and except to say that witness seems to be very well acquainted with the area, but that is version is strange because he is challenging the version of Mr. Ramsawhook. But that was the whole purpose of his evidence, was to challenge the 30 years period Mr. Ramsawhook was claiming. And the Supreme Court makes no finding at all or whether Mr. Ranoa, the witness of the appellant, ought to be believed or ought not to be believed. I'll come to that a bit later, but these are matters which I wanted to allude to your lordships in the beginning so that we know where we stand. And what my case is about, my lord, I am not challenging the finding of facts of the courts. I am saying that the facts as they are cannot lead in law to acquisitive prescription. I do not need to dwell further on the stringency of the test because I'm sure I'm not making a statement of comparative law, but I'm sure your lordships are very well familiar with the concept of adverse possession. And this is no difference, so that it is a stringent test. You cannot just come and just by mere ipse dixit say I've occupied and you've acquired. No, there are issues which are propped up in this case in the evidence, and which in fact I will humbly submit, if there were any start of occupation as a lawful owner à titre de propriétaire, it was interrupted. And I will immediately bring your lordships to document AH, which is a very important piece of evidence, which is to be found at page 669, my lords. Obviously, your lordships would have had taken cognizance of my written submission. I am not going to repeat that submission, but I just want to highlight the salient point which I believe your lordships are very important, and analysis which was not embarked. And probably before I take your lordships, first of all, to document 669, my lords. What is important in that document, if your lordships could probably tag along with me on that document. My lords, there are two matters of great importance in this matter, in this document, rather. First of all, at page 669, the first paragraph of the document, which is the judgment of the Chambers case, which recites all the affidavit put in by the respondent himself and one Mr. Tulsi, who was a co-owner. The respondent in a counter affidavit admits that the applicant is a co-owner. So there is a recognition of somebody else's right on that property. Which begs the question, then, my lord, how could he have occupied exclusively when he is recognizing the right of another co-owner? Secondly, my lord, what is important, if you go to page 670, now we are talking here in the second paragraph again of one of the heirs of the original co-owner of that plot of land. That is Mrs. Indrauti Biswani. And this is what is said, because the respondent prays in aid the support of Mrs. Biswani to buttress his case in the Chambers case. Mrs. Indrauti Biswani, in support of the respondent's affirmance, affirm in her affidavit that she is also a co-owner. She is a co-owner of the land, and that the applicant has not obtained her consent or that of the other co-owners to start proceedings against the respondents. And this is where it is more important, whose occupation of the land she approves. So therefore, my lord, put in its proper context, and may I also at this stage, for the sake of completeness, bring your lordship's attention to another judgment which I came across very late in the day, which I have shared with your lordship, which is the 2016 Supreme Court judgment, which I have mailed yesterday to the registry, and I believe it has been shared with your lordship. This is what have been indicated. Am I correct, my lords? That that judgment has been shared with you? Yes, my lord.
We have that judgment. That is the judgment by the Tulsi family concerning the Tulsi family as to whether or not their challenge to Mr. Ramsawhook's exclusive ownership of the land was time barred.
Yes, my lord.
And the court held that it wasn't time barred because 30 years had not expired.
Correct, my lord. That is correct.
Yes,
correct, my lord.
Thank you.
Yes, my lord. But what is important in that case, my lord, for the purposes of our case, we have heard from the respondent, my lord, right throughout his case, that he is occupied since 61 as a owner. But then, my lord, if you go to page 3 of that judgment I've referred, this is what the judge had to say. On the pleadings before him, at paragraph 6 of that judgment, at page 3. Are you with me, my lords? Yep. On the merits, while denying the plaintiff's claim, they admit and aver the following. The late Hukum Tulsi did in 1980 serve a notice mise en demeure on the defendant to which they were either not bound. And that is as a result of that notice which document AH comes into effect. That is the Chambers case for the writ abere facias. Before the Chambers case, which was put in during the course of the trial. And this is the most important part. The second part, the admission of Mr. Ramsawhook in his pleadings, which is an extrajudicial admission. The late Jabisia Bisuni authorized defendant number 1 to occupy the Lenite verbally since 1961. So therefore, any occupation by the respondent, my lord, was precarious. He was there as a licensee because he's been occupying with the authorization of the lawful owner. So, had the courts in Mauritius taken time to analyze the legal effect of document AH, one would have clearly seen, and coupled with that, my lord, now, if you go through the evidence, of course, there is the admission during cross-examination of Mr. Ramsawhook. He admits that officially I have occupied since 1967, my lord. The first point which I would draw to your attention is there is serious dispute as to when occupation started à titre de propriétaire in conformity with Article 2229. Because you would have... Yes, my lord?
How is that consistent with your recognition early in your submission that you're not challenging the findings of fact of the courts below?
My lord, when I say I'm not challenging the fact, I am saying that the facts are, what I mean probably is that the facts are there, but on the application of the law to those facts, the Supreme Court and the Court of Appeal were wrong.
I mean, was the judgment which you have produced, what was the judgment which you have produced and which we've been looking at, the 2016 judgment, ever before any of the Mauritian courts? I think the answer was no.
Unfortunately,
how can this court look at that document in order to impugn the judgments of the courts below?
Well, my lord, I believe that in the I concede that this was not put before any of the courts in Mauritius, that is the court of the trial court and the court of civil appeal. However, I believe that it is important to at least allude to it in the interest of justice, so that at least your lordships are appraised of it. This is part of a judgment on the. It is an extension of the 1982 case, and this is what is the stand of the respondent as regards to the 1961.
But your case, Mr. Amber, is that you don't challenge the findings of fact but you say on the information which was before the Mauritian courts at the time of their decisions, they were not entitled in law to make a finding of prescriptive possession. Now that cannot, this document cannot be relevant to that challenge.
Certainly, my lord, I fully concur with you on that issue. As I said, I felt duty bound to bring it to your attention in the interest of justice. Quantum variat, whatever your lordships may make of it. I am not saying that you should rely on this. Far from that be my contention. And I'm saying, my lords, in the absence of this document as well, my lord, there is enough evidence on record which shows the precarious nature of the occupation of the respondent. And that, my lord, if you go, first of all, the admission of Mr. Ramsawhook himself, that he officially occupied from 1967. So that, in what the question, which begs the question, in what capacity was he occupying between 61 and 67? And I humbly submit before your lordships that the 61 and to 67 occupation by Mr. Ramsawhook is, to say the least, unclear, unprecise, and contradictory to his own admission that he occupied in 67. And when it is put to him on that single issue, my lord, when it is put to him, therefore, is the judgment of 1982 incorrect on the basis the judge found, if you go to page 671 of document AH, my lord, first line, second sentence, he affirms that he has been occupying the lands over since 1967. Now, my lord, in order to dispossess a lawful owner of his title, I believe, and I humbly submit before your lordship, that the test is stringent and the requirement must be satisfied in a very stringent manner. Faced with this contradiction between 61 and his admission that he occupied in 1967, because it's very simple, my lord. If we start from 1967, then his affidavit of prescription falls short by 2 years. And therefore, and I believe we should not forget one thing very important in this case, my lord. The Court of Civil Appeal, on a review of the evidence, found that Mr. Ramsawhook was inconsistent and was a person of bad faith. Now, the other thing the Court of Civil Appeal relied on to say that the trial judge got it right was the evidence of the gentleman from the Sugar Insurance Fund Board, Mr. Gamundi. That is, his evidence is up page, if you just bear with me 1 second, my lord. 935 of the evidence, of the bundle, stripped down to its bare bone, my lord. What does Mr. Gamundi say? Mr. Gamundi says that, in fact, Mr. Ramsawhook has been a owner since only 1980, has been a cultivator of sugarcane only since 1981, up until 1995. Prior to that, my lord, there is no record, nothing to show that he planted sugarcane. My lord, without giving evidence myself, but one should bear in mind, in Mauritius, all sugarcane planters are by law required to go with the Sugar Insurance Fund Board for purpose of cyclone, drought, and so on, for their insurance purposes. It is a matter which all sugar planters have to do. So that it could not have...
Yes, it's quite common in Mauritian acquisitive prescription claims to have evidence from the sugar fund board.
Insurance fund board. Yes, my lord.
I've seen this before, Mr. Rapp.
Yes, my lord. I think, my lord, to be honest, it's because of the requirement of 2229 that you have to show certain external appearance of occupation by way of plantation or an enclosure and so on and so forth. So
your point clearly is that he is only speaking for the latter period of the 30-year prescriptive period.
Exactly, my lord.
He can't speak for the years before 1981.
Yes, there's nothing in there.
Right.
Then the next witness was called was the neighbor who at 11 years old could not say which part of the land. But there is one important piece of information which he gives us, my lord. And for that purpose, I will have to refer your lordship to document AA, my lord, which is to be found at page 653, so that your lordship can understand exactly what I'm talking about. If you look at document AA, my lord, this is the site of the property in Lite, which is subject matter of this appeal. It is to be found in the yellow strip, which is said to have been occupied by the respondents. And on the left side is the Bisunis, when you are looking towards point B, which is on top of the page. With me, my lord?
Just document AA, I see it on its side, but there are three colored areas. There's a blue color, there's a sort of beige color, and there's a beige color.
Yes, the beige, in fact, my lord, the blue and the beige color is the property of the appellant. So you will remember that the original plot of land between the three co-owners was about 22 arpents and some purchase. Now, it was divided equally between three co-owners, each one having 7 arpents 42 purchase. So on the left side were the Bisunis, who have sold to supposedly the undergrad rights, but this is a matter of contest. I'll show you to you later. Then in the middle was for the authors of the appellant, the predecessors in title plus her father. And on the right-hand side were for the other co-owners, the Sigulam. And what is important, my lord, here, this is why I want, is if you go to page 941 of the... Now, this witness...
Just before we do that, on
Yeah.
this map AA, is the area outlined in red? What is that area?
Well, my lord, this is where you since the identity of the land is not an issue, so I didn't bring your lordships to this issue. But what happened in effect is, if you see like a triangular strip which is left at the top on the left side between the two plots of land, there's a small strip in a triangular form. Yeah.
Yes, I see that.
And then you'll find the red boundaries which make the land in a square form.
Yes.
All throughout. Right. What has happened is, in fact, the respondents prescribed up till the boundary with the green line. But when the division in kind took place, the then surveyor of the respondents squared the land basically and took an encroach over that overlay of that triangular piece.
Yes, I see. Thank you.
Yeah. But what is important, my lord, you will see next to the Sigulam, therefore on the left of the Sigulam, when you're looking from the plan, is the land of the appellant. And you will see at page 941, when 940, which starts, around 67, he built his house. And then when we come to the distance, where were you seeing him on the land? near lowland, near the land of Mr. Ramsawhook, not a bit far. So that Sigulam on the right, the far could not have been the land adjacent, must be necessarily on the extreme left. And at any rate, my lord, if you go through
I do apologize. What are you taking from page 941?
when you see the witness Rapua,
Yes.
right, is when he was asked what is the distance between where you saw the Ramsawhook and that of the Sigulam. Did you know once, see at 940, my lord, you must stop at the bottom of 940. Did you know one Mr. Sigulam? Yes. How do you know him? I know he's a resident of the village there. Were you seeing him on the land, near your land, near the land of Mr. Ramsawhook? No. So the land of Mr. Ramsawhook, not near, a bit far. But of course, the land which is adjacent cannot be far. The only land which can be far is the land of the extreme left. Yeah.
Thank you.
And the other thing, my lord, oh, sorry.
Just before we leave the plan on page 653, could you just clarify for me which is the disputed land that we're actually talking about on that plan?
Yes, my lord. It is the land which is shaded in beige or yellow. In the middle portion.
Without the orange outline, it's simply the
the whole of the strip up till the blue part.
Thank you very much.
Yeah, and you will see there is a yes, my lord. Yes, my lord.
May I just ask also, you've drawn our attention to the difference between the green line and the red line.
Yes.
You're not relying upon that difference in the context of this appeal as being a material difference.
My lord, this will be, unfortunately, if I am successful, my lord, this will have to be the subject of another dispute probably, because there's something else also. You will see that the blue part still stays for the appellant, still remains in the possession of the appellant by title, but it's landlocked. There's no access to that land. So that would be something, but for the purpose of the appeal, I'm going only on the shaded part, which we say has been prescribed by the respondents, my lord.
According to the statement of facts in issue, the land that is in dispute is not a matter which is before us. Are we to take at this stage everything that is coloured beige as being the land in dispute?
Correct, my lord.
Thank you.
Now, my lord, another important matter in the evidence, and this is also very important, is when asked whether he occupied, at no point in time you would have seen that in the evidence of the respondent, he comes and says that, yes, I knew the land was for Hurhangee and I took it. No, that is not his version. His version is, I've occupied what was shown to me as being my boundary. So all throughout, believing, probably mistakenly, that the whole land is supposedly and allegedly at board, was that old area. But here, my lord, there is a very fundamental issue, which you will see crop up in the case of Kamlaville, which is at tab 14, my lord, at page 1150. Bear with me, my lord. Right. If you go to that judgment, my lord, at page 1149, and you will see in here, in a nutshell, my lord, there was an outpost which was along with the land, and the person who was claiming to have possessed it for more than 30 years believed that it was part of his title. And this is what the judge had to say. I have referred to the fateful date of 1982 when defendants sole land surveyor entered the scene and uncovered the truth about their being possessed of the property of another. In these circumstances, a clear animus domini of acquittal provision from the defendant's part may only begin in law from the time his possession became opposable to the plaintiff's society. Time would only start to run from the moment it became clear to the defendant that the land occupied by him is not his. And this takes all its importance here, because all the while he was occupying, he thought it was his land, according to the boundaries showed by him, by Bissuni to him. So he was not encroaching onto my land and taking possession of a third party. And this also, there is no analysis. And the learned judge went on to add, the answer has been given in no uncertain terms in précis de droit civil, verbeux de la propriété, paragraph 1450. Le fait admis, my lords, if there is any issue, while I'm repeating in French, I will do the loose translation, but I'm sure your lordships are very able in French, probably more able than me. So, le fermier qui possédait des terres au-delà ou en dehors de son titre, peut-il en acquérir la propriété par prescription? Oui, sachant qu'elles ne sont pas comprises dans son titre, therefore, knowing that it is not comprised in your title, you will have the animal domini. Il les a possédés animaux domini, non s'il les croyait comprises dans son titre, car alors il les appelait sine anno domini, donc à titre précaire. So therefore, if you believe that it was part of your land, always, and then all of a sudden we realize that in fact it's not yours, time only starts then. But this, unfortunately, my lord, was not the subject of any analysis. So then his lordship went on, in these conditions, the fact would have that his prescription period may only start from the time he formed the necessary intent. So we have seen, I've alluded to your lordship, to the fact that all throughout in his evidence, he says that, well, it was part of my land, I haven't taken anybody's land. And he even goes further. At my age, I will not steal somebody. I mean, I'm sure your lordships would have seen that in the evidence. At my age, I will not steal somebody else's land. That's what he says. So therefore, that makes him lack the animo domini in the circumstances, my lord. Now, my lord, we have seen in the document AH on a proper construction by virtue of the affidavit of Mrs. Bissuni, in that case, which was prayed in aid by the respondents, he was there by mere license. Now, the next question is, there are 2 points here, my lord, is under Article 2240. He is occupying, therefore, by way of a title, the title being a license. Can he prescribe against that title? 2240 tells you no one can prescribe against his own title, and for good reason, because you cannot substitute yourself to yourself. That is the principle. But there's worse for the respondents, my lord. What is his case? His case is not that I have both the undivided rights or I'm occupying with a license. I have purchased, I've acquired. This is what is the case of the respondent. And I believe it is very important at this stage, my lord, for me to bring you to the plea offered by the respondents in this matter. You will see the plea as from pages 27, I believe, my lord, 26 of the, and more specifically, I am referring to paragraph 2 and 3. The defendant denies paragraph 4 of the defendant, however, that in 1961, the defendant number 1 acquired. That is,
I'm so sorry. Could you give me that page number again?
Yes, my lord. It's page 27.
27. Thank you.
In 1961, the defendant number 1 acquired from Mrs. Jibisia Bisoni all undivided rights in a plot of land of the extent of 7 arpents or 31,441.21 square meters at Australia. And I hasten to add, my lord, besides the word of Mr. Ramsawhook, that is bought, that acquired in 1961, there is no document to that effect. And no document has been forthcoming in this case regarding that specific purchase. And funnily enough, he says the authentic deed could not be finalized in as much as Mrs. Jabisia Bisoni did not at the material time acquire the other undivided rights. In 1967, in virtue of a deed under private signatures, dated 2nd June 67, the defendant acquired from Mrs. J all her undivided rights in the same plot of land. So, if we see now, my lord, we do not have anything for 61. We have the admission in evidence that is occupation only, and he says officially 1967. Officially, that is caractère public. The public character which is required under 2229 only kicks in 1967 on his own admission. So that, going back to the length and duration of occupation of 30 years, he could not have satisfied that, my lord. Yeah, my lord.
Could I just test that point? Are you saying that where 2229, Article 229, speaks about une possession publique, it requires a public document, or is it not simply that you possess openly?
No, I believe.
Well, see you.
No, I do not believe it is a question of document, my lord, because for the simple reason, if I have a document, therefore, I would probably not need, if I have a title, I would not need prescription, basically.
Well, clearly, if you've got a title, but in this case, what you were saying is that there was a deed under private signature dated in 1967, and therefore it wasn't public until 1967. I want to test what you're trying to say.
Public means, my lord, you go on the land and you occupy it in public as the owner. This is what it is.
Precisely. So why does the fact that there wasn't a document before 1967 assist your case?
But, my lord, because of his own admission that officially I occupied since 1967.
But
we have a contradiction.
But if you publicly occupy the land, whatever your official status is, how presumably that open, as they'd say in Latin, nec vi, nec clam, nec precaria, and nec clam is the relevant prescriptive criteria. I.e., you're not doing something secretly. You are openly occupying the ground. Now, if you are openly occupying the ground, then it matters not whether you've got a document of title. The prescription runs by virtue of your open occupation, as long as the other criteria are met. And you argue, of course, that.
Yes, my lord. But as I've alluded to you earlier, I do not believe that the other criteria have been met as well in this matter. So when you add all together, the possession could have only as a simple licensee, at least on his own admission in 1982. So time could not have run against anybody till 1982. My lords, according to my watch, it's nearly quarter past. Would you think it's an appropriate time? Sorry, I can't hear you.
So I'm so sorry, Mr. Amber. It's 11:45 that we'll have the break. Thank you very much.
Oh, sorry, I heard quarter past. I'm so sorry, my lord.
An hour, we're giving you an hour and a quarter, and then we'll have a break.
Sure, my lord. Yes, my lord, I was with the plea of the, if we continue, my lord, with the plea, if we go to now, in 1967, we've gone through that document AF. Now, my lord, it is important for you to examine document AF to understand its purport. And I shall ask you to immediately to turn to page 1039, document AF. Right. This is not a sale, my lord. It is an undertaking to sell. And that also, it is the brother-in-law who undertakes to sell the undivided rights of one of a sister-in-law, and also undertakes to have the other co-heirs in the succession to sell their undivided rights to the respondent Ramsawhook. And this is also, you will see it's in the third paragraph, the said Sidalal Jitan further undertakes to cause to be sold to the said Iralal Ramsawhook the said undivided rights for and in consideration of a price of 1,665, out of which the said Sadial Jitan in his aforesaid capacity acknowledged having received now itself the sum of 300 rupees for the cost of the sorting out the said successions. So, my lord, there was at that time, even in 67, as we can see, he is occupying by virtue, according to him in his own mind, by virtue of a deed, not by virtue of occupation animo domini. And as I alluded earlier, my lord, the recognition of the other co-owners in the land abruptly stopped any possession ab animo domini. This is what the law says. Then it goes on, my lord. Since the said sale could not be embodied, if on paragraph E, page 27, since the said sale could not be embodied into an authentic deed of sale by virtue of an affidavit of prescription dated 12 January 1995, the defendant acquired by acquisitive a plot of land of 11. Now, he recognized, you will see that the superficie is much more, but all along in the case of the Ramsawhook, it was about 7 or 45. Now, when does he move on to the land of the appellant, which is dot number 2? There is no evidence to that effect. Because what is clear, my lord, from the evidence and the pleadings, is if Mr. Ramsawhook has gone onto any land, it is the land of the Bisuni. Then he moved on to the land of the appellant. But when? For the sake of certainty, for the purposes of his prescription. it was important to demonstrate that and to show that. But this he has singularly failed to do, my lords. Now, my lord, the next thing is, riddled with such inconsistencies, can one say that on a balance of probabilities, with the stringency of the test required, can we say that he had satisfied the burden of discharging that he had possessed with all the requisites in the circumstances? On a proper analysis, my lords, I believe no. And that analysis, my lord, I will go even further to say that even if it wasn't done by any counsel in the case below, it was the duty of the trial court to do so. And I say so advisedly, my lord, on the authority of Camlaville, tab 15. This is what the judge says about the legal aspect of it. If just bear with me, my lord. Right, if you go to page 1143, my lord, and you will see in the third paragraph, no submission was made on the nature and quality of the possession, presumably because this aspect of the case, learned counsel must have thought is a matter for the courts. As has been pronounced by doctrine and case law, les juges du fond jouissent d'un pouvoir souverain pour apprécier les circonstances de chaque espèce, la nature, l'existence des actes de possession pour prescrire les vices ou l'absence de vices de possession. So it is for the judge to go and embark onto that and look at the quality and nature of that possession. Sufficient issue was brought to the attention of the learned judge for this analysis to be embarked upon. And even in the bundle of authorities submitted by my learned friend for the respondent, if you to go to page 1205, note 30, possession civile, la possession servant de base à la prescription doit être une véritable position civile à titre de propriétaire. Il appartient aux juges qui admettent le jeu de l'usurpation de caractériser la possession. This exercise, unfortunately, my lords, was not carried out by the trial judge nor by the Court of Civil Appeal in the present matter. Now, insofar
just looking at that passage, you were making a submission based on Camlaville that one couldn't have animus domini if you thought you had a title, rather than merely seeking to create a title by occupation. But this passage, paragraph 30, describes animus domini as l'intention de se comporter comme le véritable titulaire du droit exercé. So you're intending to comport yourself as the person with title to the right that's being exercised. it doesn't seem to support the learned judge in Canterville.
No, this it is what my point here is, my lord. It is for the judge to define the nature of the possession. That is my point here.
Well, I know that's your point, but my point is looking at the same passage to question your interpretation of what animus domini actually requires.
Yes. Sorry.
Because it goes on to discuss animus domini, animus domini and precarious detention, precarious occupation in the next paragraph, 31.
Yes, les deux composantes traditionnelles de la possession sont le corpus, la maîtrise matérielle de la chose, et l'animus domini, l'intention de se comporter comme le véritable titulaire du droit exercé. My lord, if it is so, then it begs the question, why in 1982, and I will bring your attention to something more important as well for 1982, why in 1982 he seeks in aid.
I wonder if I could pause. Mr. Chung, you disappeared temporarily. Can you still hear us?
Yes, I can, my lord. That's why I moved up, because I just saw everyone going offline, and I was like, something must have gone wrong on my side. But yes, I'm back with everyone now.
You didn't miss anything then, did you?
The last conversation that Mr. Rambert was having with you, my lord, was with regards to the répertoire d'allures. Your lordship was saying that the paragraph 30, the part that has been read by my learned senior counsel, did not tally with his submission with regards to the case of Kamlaville, and that then you went on to read the paragraph 31. Did I get everything right?
You've missed nothing then. That's fine.
All right.
I'm so sorry, Mr. Ramburn, but I wanted to make sure that
yeah, certainly, my lord. Most certainly, my lord.
Informed.
My lord, yes, I was on the. Then it begs the question, my lord. Why, if you believe you are the title owner by occupation for more than 30 years, do you seek the aid of the co-owner? You recognize the right of the co-owner, of two co-owners at least, Tulsi and Indra Biswani, and Indra Biswani in the affidavit says that, well, I've given you authorization to occupy. Surely that cannot be anima domini. Now, my lord, there is something else. There was a defense open to the respondents in 1982 if they had really occupied since 1961 as they claim. You will see, my lord, in the case of, if you bear with me, the case of Jordan, I think, my lord, page 1114. Bear with me, you'll see the point I am trying to make, my lord. Yes, if you go to page 1119, my lord, middle of the page, following the amendment of the law in 1983, Act 9 of 1983, the period of acquisitive prescription under Article 2261 of the Civil Code was extended from 20 years to 30 years. So that in 1981, when the case is lodged against him, his first line of defense could have been what I've occupied for 20 years. I am the owner by acquisitive prescription. There was nobody, he needed anybody to support his case. So the only inference we can make in those circumstances, my lord, is that there was no occupation since 61. It could have only, if there was any occupation of the appellant's land, it could have only been after, and any other part of the land, it could have only been after 67, my lord. That's why that first line of defense, which was available, was not recourse to. Now, my lord, your lordships will also bear in mind and would have seen that when you have co-owners and you are prescribing against co-owners, the test is even more stringent because you have to show l'interversion des titres. That is, you have ousted your communists completely from the land to your exclusion, to the exclusion of the others and for your own sole behalf. And the test is more stringent. And coincidentally, my lord, I know I'm just as a matter of interest, just drawing your attention. In the 2016, you would have seen what is the line of defense is prescription for 10 years. That is de bonne foi et à juste titre in the 2016 case. It is not the prescription cantonnaire. And in support of what I've just referred to, that the test when you are ousting other co-owners is the case of Jagannath. You will see at page 1112, first paragraph. It has to be borne in mind, are you with me, my lord? It has to be borne in mind that a communist who claims to have prescribed a portion of land against his co-owners has to satisfy a more stringent proof than in other cases. He has to show proof of his exclusive possession to demonstrate clearly that he was ousting the other communists. But here we have the other communists saying that no, in fact, he's occupying with my authorization.
But would that not be res inter alios acta as far as Mrs. Hurhangee is concerned? I mean, it may well be that the two family may have some sort of claim against the Ramsawhook family, but this is concerned with an assertion by one co-owner against the other co-owners. I don't see how Mrs. Hurhangee can pray in aid this doctrine to a
No,
she is not a co-owner with the respondents.
my lord, it goes to the precarious nature of his occupation, because he says at no, this is why I said earlier, at no point in time he says that I've occupied the land of Mrs. Hurhangee. In his mind, he's always occupying the land of the Bissonese. And if I may, refer to you at page 1209, under note 41, in the middle of the page, just after the citation of the judgment number 158. Do you see it there, my lord? In the middle. Le vice d'équivoque entache la possession de manière absolue à l'égard de tous. And again, il revient au juge du fond de lever l'ambiguïté quant à l'intention de possesseur de se comporter en véritable titulaire du droit. So here we are in a situation where Mr. Ramsawhook claimed to have possessed the land of the Bissonese because he could not draw up an authentic deed, and he goes on to occupy the land of the appellant as well. but it is the beginning of the occupation itself is entaché d'évis, de précarité. So therefore, it is precarious right from the beginning for everybody. Now, my lord, another concept one should not forget is if you accept my case theory that between 61 and 67, he was possessing the land on behalf of Mrs. Bissouni until 1967, when he claims, I mean, I'm giving his case in the best light, he came and occupied Animo Domini from 67 and officially. So the period of 1961 to 1967, his possession could have been only on behalf of somebody else, that is Mrs. Bissouni. Now, when you will see that the when you occupy for autrui, you can never prescribe for yourself. So that the starting period between could not have started in 61 at any rate, on his own account and in the light of the evidence and the documents on record. Your Lordship could just bear with me 2 minutes. I'm doing this, seeing if I've covered everything I wanted to cover with your Lordships in this matter. Now, my Lord, the next thing I would like you to consider is page 11. In the bundle of authorities, 1133, page 1133. And I am referring to tab 13, my Lord, the case of Parmesar. Okay. 14. Le titre qui s'oppose à la prescription acquisitive peut se transformer de manière à changer la détention en possession animo dominale. Autrement dit, ce qui doit être modifié, ce n'est pas le comportement du détenteur, mais sa cause. Tant que celle-ci repose sur un titre impliquant la reconnaissance du droit d'autrui, la précarité subsiste. Et cette situation de perpétue au-delà de l'arrivée de l'époque fixée par la restitution de la chose. Ainsi, un fermier ne commencerait pas à prescrire le fonds du seul fait qu'il en conservait la détention après la cessation du bail. C'est ainsi qu'encore que l'interversion du titre ne résulte pas pour le tuteur en ce qui concerne les biens détenus dans le cadre de la tutelle, ni de la cessation de la tutelle, ni de la reddition du compte, ni même and so on, my lord. So here if you have acknowledged the rights of property of the Bisuni, which he acknowledges, therefore he could have only occupied on their behalf, so that he could not have translated it into an animo domini for himself. The occupation, therefore, is precarious. Now, if you go to note 96 at page 1223 from the bundle of my friend, l'interruption peut aussi émaner du possesseur qui reconnaît les droits du propriétaire contre lequel il prescrivait. I know, my lords, you will tell me that the Hurhangee cannot pray in aid this part because he is possessing for the Bisunis. But you must bear in mind, in his mind, according to his evidence, the whole lot was for Bisunis because this is the boundary shown to him. So that, as I alluded earlier, the vice in his occupation is toward the appellant as well, as I cited earlier, the authority which shows that. La prescription étant fondée sur une position à titre de preuve, il est normal qu'elle cesse quand le possesseur admet détenir la chose pour autrui de façon précaire. Mais cet aveu provoque en même temps que l'effet interruptif une intervention de titre. Celui qui est devenu simple détenteur précaire ne pourra plus alors recommencer à prescrire, sauf à ce qu'il apporte plus tard une contradiction au droit du propriétaire capable de changer à nouveau son titre.
I wonder if you could pause, Mr. Chung, as we've lost him temporarily.
Yes. Okay.
Mr. Chung, you're back with us?
My lord, it seems that the issue seems to be on my side. I'm presuming that my senior counsel was reading the rest of paragraph 96 of the Répertoire d'Alleuse then.
That is what we were looking at.
Right.
There have been no submissions. He has merely been certified. He's been reading out to us the content of paragraph 96. Mr.
That's fine now.
I'll ask you to summarize your position in relation to that. Mr. Chung knows where we are.
My lord, if we go to now, note, these are the bundle of authorities provided by my friend. If you go to note 1205.
I wonder, before you go there, could you just summarize? You were looking at paragraph 96 and reading it to us.
Yes, my lord.
What did you take from that paragraph in relation to the circumstances of this case?
Yes. The act of recognition of somebody else's rights in the land can, first of all, emanate from the possessor himself. And in this case, the Ramsawhook recognized the rights of the Bisunis and the Tulsis as well. And this is why I say, probably your lordship will tell me that when you read it, the full first sentence, l'interruption peut aussi émaner du possesseur qui reconnaît les droits du propriétaire contre lequel il prescrivait, so that Hurhangee is not the one whose rights he has recognized. So therefore, Hurhangee would not be able to claim this in aid. I am fully alive to that. But my argument to this, my lord, is that you must look at the mindset of Mr. Ramsawhook at the time. The mindset of Mr. Ramsawhook that he was prescribing the land of the Bissonnese according to the boundaries shown, even if that included that of the appellant. And as I had earlier alluded, your lordships, to the reference in note, the earlier note I showed your lordship, que la vis entache alors contre tous, then therefore even Hurhangee would be able to claim that this is there is a defect in the occupation. Who had also, because he went on the land believing that the whole land was for the Bissonnese. And if your lordships go further down to note 40, qualité de la possession.
This is page
1208, I'm sorry, my lord.
Thank you.
L'absence d'interruption, if you look at the last two sentences and over the page to 1209, toutefois, deux des conditions énoncées, l'absence d'interruption et de précarité, ne sont pas réellement des caractères de la possession, mais des éléments constitutifs de celle-ci. Ainsi, l'interruption ne vise pas la possession, elle la fait perdre purement et simplement. So, if that constitutive element is not there, therefore, purely and simply, even you are in possession, all the requirements of the constitutive elements, you lose the right to go for acquisitive prescription. De même, la précarité exclut que l'on ait affaire à une véritable possession animo domini. So precarity then will always play against and is always a trump against possession animo domini. I am sure when your lordships would see the sum total of the evidence and the documents ushered in this case, one can only come to the conclusion that the possession was not animo domini. There is serious precarious qualities in the possession, so that in law, the respondent would not have prescribed the land of the appellant, and the Mauritian courts would not have found in law in his favor, my lords. Maybe, my lord, that would be the convenient time we just take a short break and then I'll wrap up my submission, if that is convenient with your lordships.
Yes, and no one seems to be wanting to ask a question at this time. So all you need to do is put your microphone on mute and stop the video, and we will resume in 5 minutes' time. The court will now adjourn. Mr. Rambo, I think we're now in a position to resume. Thank you very much.
Yes, my lord. My lord, did I bring you to page 1205, my lords, earlier? I'm not too sure. Did I bring your attention to note 1205, note 31 and note...
We looked at 1205 for paragraph 30, that the fact that judges must characterize the possession.
Yeah.
If you're wanting to look at paragraph 31, we can return to it now.
Yes, if you can turn to this, my lord. Le simple détenteur du bien ou du droit qui le possède pour autrui ne peut jamais prescrire quel que soit le temps écoulé. So this is a very simple proposition in law, my lord, that whatever the time which may have elapsed, if you possess for somebody else, you can never prescribe. It's very simple proposition. Le détenteur précaire est celui qui exerce le corpus d'une chose qu'il sait ne pas lui appartenir. And this is where this has become very important, I believe, my lord. In his mind, the Hurhangee was never in the picture. He was always occupying a land which was his, which he believed he had bought by way of acquisition of a undivided rights.
The sentence you're referring to, it
Yep.
says that the occupier, precarious occupier, is someone who has the body of the thing, who knows
Yes.
that it doesn't belong to him.
Yes.
But how does that apply here?
Yes, my lord. In his mind, he was always occupying his own land. It's not the Hurhangee was never in his mind, according to his own evidence.
But this passage is saying the precarious occupier is someone who knows that it doesn't belong to him. Is that not what it's saying?
Yes, but my lord, his occupation for the purpose of 2229 must be precarious because he's occupying because of his purchase, not animo domini à titre de propriétaire, knowing that it is not for him.
You say he's precarious because he occupied because of his purchase. He went through an informal, according to his case, he went through an informal purchase back in 1961, which was formalized to a degree in 1967. But in what sense, if you informally agreed to purchase land and paid money, in what sense are you occupying it for someone else? Just because the sale hasn't actually transferred title.
But my lord, this is where where he comes and says himself that he had the authorization of the original owners. That is where it is important. He loses all the quality which he requires for his possession to be animo domini. That is the central issue here. Could he have started in 61? Could he even have started in 67 for that matter? And could he have even started in 82 when he prays in aid another co-owner to help him out? Is recognizing the rights of others on the land. May I also, since your lordship referred to document AF, but a close examination of that document, my lord. Let us try to read it together and see what is the real purport of that document. Is it a sale at all? The said Mrs. Yes, my lord.
I beg your pardon. Could you just direct me again to the page which you're about to read from?
Oh, sorry, my lord. Page 1039.
Thank you.
Yep. If we read it, the said Mrs. Jabisia Bisuni is owner of undivided rights in a portion of land of the extent of 7/45 purchase, situate and etc., for having inherited same from the succession of her father, Mr. Bisuni, who was the owner thereof for having himself and also inherited same from the succession of his mother, Jamuni Bisuni, who had herself made its acquisition according to title deed transcribed in volume 214, number 473. the said Mr. Sidyal Jitan, acting in his aforesaid capacity and with the authorization of Mrs. Jabisia Bisuni, bind the said Mr. Igalal to take all the necessary steps for the regularization of the above succession. So that is the first thing he has to do, is regularize the succession and to bear all costs for the sorting out of the said succession in order to allow his sister-in-law, the said Mrs. Bisuni, to sell to the said Mr. Igalal Ramsawhook all undivided rights generally belonging to her in 7 upper 45 pairs. So therefore, it is only the sale of the undivided rights of Mrs. Jabasia Bisuni, not the other co-owners. That is the first thing here. The said Mr. Then you have the two other conditions which I've gone earlier. So to what extent, therefore, is this a sale? But my submission on this document alone is that when you read the document, any occupation by Mr. Ramsawhook was waiting for the formalization of the succession papers to be materialized. So that in itself, therefore, my lord, I will humbly submit, demonstrates some precarious nature of his occupation. Because at the same token, my lord, one cannot enter into an agreement to purchase the rights of somebody else and then pass on as the owner at the same token. My lords, I believe I've gone through my case as I wanted to show you. I would be very happy to answer any questions if any of your lordships would want me to. Yes, my lord.
Lord Byers.
Mr. Ramburn, can I just ask whether there is any date from which you would concede that the respondent was occupying in a way that would give him acquisitive ownership in this situation?
I'm sorry, my lord. Can you just repeat the question? I missed out the beginning.
Yes, I mean, you've sought to knock down that the relevant requirements for acquisitive ownership started in 1961.
Yes.
Is there any date that you would concede the necessary requirements for that acquisitive ownership have been satisfied on these facts?
To the extent, therefore, my lord, that I am going on the basis of the evidence of the respondent themselves. 61 to 67 could not have been satisfied in any way whatsoever. For the purposes of argument, let us assume I concede that it starts in 67 or thereafter, after the signature of that document, my lord. Then my point is that he is still short, my lord, by 2 years.
Yes, I understand that. I thought you were taking us to the document that you were just taking us to show that even in 1967, the requirements were not satisfied.
Yes, this is also part of our case, and this is confirmed, I say, in the 82 document, when he prays in aid another co-owner to say that he's staying there by authorization.
So what I'm putting to you, it may be that you're choosing not to answer. Is
No,
there
no, no,
any-
I don't.
No, I'm just seeking to know whether there's any date where you would concede all the requirements are met.
My lord, I believe none of the requirements are met. This is my position. I on the basis of the evidence before us, I would maintain that there is the requirements are not met, my lord.
Well, I can understand you saying they're not met in the time period of 30 years, but are they otherwise met for any periods of time at all?
Well, even for my lord, they at the best he could have met for the Tulsi and all this for the 10 years à juste titre, but that's about it. Not the 30 years. No, it doesn't satisfy the appellant.
Thank you.
I'll see if anyone else has any questions now. We will, before we hear from you, Mr. Chung, we will have a short adjournment so that I can take stock with my colleagues as to the matters on which we may wish to hear from. We're now ready to resume. Mr. Rambo, thank you very much for your submissions. Mr. Chung,
My lord.
I wonder, without constraining you in your reply in any way, if you will include in your reply an explanation of the animus domini and a view as to whether what the learned judge said in Camberville at 11:49 is good law. Secondly, if you cover the concept of precarious possession in the light of Article 2236 of the Civil Code, and also help us, if you would, on whether there's a duty on the court to explore matters, or whether there's merely an opportunity for the court, if it wishes, to explore matters if it wants to.
All right. My lord, how I will proceed is that I will go through some parts of what I've already prepared in rebuttal. I will not go through the written case of the respondents because it is already on record and everyone has it. And then I'll try to answer the three questions that your lordship has asked me to. First and foremost, my lord, regarding the last case, the 2016 case of Tulsi and others against Ramsawhook and others, SCJ 348, my lord, this case and the evidence in this case, whereby the pleadings and whatever has been mentioned, it was not is not evidence at first instance, no on appeal. So that's why I would ask this board to disregard this matter. My learned senior counsel for the appellant has made a couple of remarks regarding this matter. I believe they should not be taken on board by this board when finalizing a judgment regarding this. The appellant has in their written case, but Mr. my learned senior counsel has not alluded to the issue of interruption. Since it is already on my list of things that I have written down, I will just take your lordships there. In the written case of the appellant, they have pleaded that there has been an interruption regarding the previous case, the case of Hukum Tulsi against Ramsawhook, the 1982 matter. I would state straight away that I disagree with that position in law, because from my reading of repertoire d'alerts, it does not seem to have amounted to an interruption. If I could take your lordship to that third document, which I believe is that page 669, my lords, 669 till 671. Your lordships will see that this is an application for writ aberré facias, which is made by way of motion and affidavit before the judge in chambers. Also, an important fact in this matter was that the applicant, Mr. Tulsi, lost the case. If I could now direct your lordships to Répertoire d'Alleuses, paragraph page 1218. Paragraph 78 starts with les causes d'interruption, so what can amount to an interruption in this matter. If you go on to paragraph 80, my lords, you shall see that it states as follows. La citation en justice représente ainsi l'unique acte interruptif dont peut user le propriétaire pour revendiquer son droit. A contrario, tout effet interruptif est dénié aux actes de type conservatoire. Now, it continues further. If I could direct your lordships to page...
Which paragraph were you looking at? I do apologize.
My lord, it's paragraph 80. It's la liste des actes interruptifs. And then the third line of the citing en Perrault, la citation en justice représente ainsi l'unique acte interruptif dont peut user le propriétaire pour revendiquer son droit. But it continues. A contrario, tout effet interruptif est dénié aux actes de type conservatoire. Now, if I could direct your lordships further down this répertoire d'Alleuses, paragraph 90, remise en cause de l'effet interruptif. All your lordships with me? À côté de cela, certains événements sont de nature à remettre en cause l'effet interruptif. Le désistement du demandeur, la péremption d'instance et le rejet définitif de la demande rendent, comme par le passé, l'interruption non avenue. Dans ces cas, le délai est censé avoir continué à s'écouler normalement. If I could then direct your lordships to paragraph 91, it's on the 9th line. It starts with « C'est d'ailleurs là le principal intérêt de la disposition ». Are your lordships with me? All right. C'est d'ailleurs là le principal intérêt de la disposition. Vu que le rejet de l'action en référé being the judge in chambers, I've stated before that the application for writ aberré is one lodged by way of motion affidavit before a judge in chambers. Therefore, this type of action falls within what is being contemplated by Dalleuses in this part. Vu que le rejet de l'action en référé du propriétaire n'interrompt pas la prescription, l'action, au fond, doit être introduite avant que ne se réalise l'usurpation au profit du propriétaire. The other paragraph relevant to this is paragraph 92. Basically, my lords, if you would look at the reading of paragraph 92, it states that the appeal delay must have lapsed and there has been no appeal, etc. The fact that this case dates 1982, I can safely say that there has been no appeal of it because there's no judgment, but we are now aware that they have lodged some sort of main case. So for me, that part, the 1982 case, given the fact that it's been set aside, does not amount to any interruption. Now, the main argument of my learned senior for the appellant is dispute between the dates. He has contended that the the prescription period could not start in 1961. At best, I believe if he was to concede, it would be 67, but I don't think he has conceded on that. So I'll go on to that. I will still be staying with répertoire d'Arlos.
We will need to pause. We've lost Mr. Chung.
Yes, my lord. I apologize for that. It seems that I am losing connection quite often.
That's all right. You can proceed. You were going to take us to another part of the Rakai dialogues.
Yes. If I could take your lordships to paragraph 32, which is found at page 1206 of the brief. It talks about the that is one of the questions that your lordship has asked me regarding the explanation with the animus domino. That paragraph reads as follows. Preuve de l'animus domini. En cas de litige, l'animus domini est présumé pour celui qui possède matériellement la chose. For recap, at the time in 2012 when the matter was first heard before the trial judge, the defendants were in possession of the land in lite. So from there, there is a presumption that the animus domino is in favor of the respondent number one, having used the affidavit of prescription before making the division in kind, whereby all the other respondents became owners, each of their separate plots of land. Then it continues, line 3. C'est sur l'adversaire que pèse la charge de prouver la précarité de la possession en produisant le titre qui fonde la détention. Now, in this case, the appellant, during the course of trial, did produce her title to it, but if I could continue reading from that, il suffit de prouver que la détention était à l'origine précaire, then, au détenteur, ensuite, le cas échéant, d'établir qu'il a endossé un autre rôle et possède dorénavant pour lui-même et à titre de propriétaire. So basically what has happened, my lord, is that the evidence on record from respondent number one shows that his version has been that he has been occupying the land since 61. This version, I understand, is disputed by the appellant, but that is his version. He has started occupying the land in 61, having grown vegetables and then later sugar canes on it. So the fact that at the start of the case, he was, well, because of the division in kind, they were in possession of the land. I would submit that there was a presumption in favor of the respondents that they did not have to prove the intention element that my learned friend has been going along regarding the values that has been cited. Now, that is one point we have gone through. Now, my learned senior counsel for the appellant has also raised the issue that the Supreme Court did not state which year, that is in his written case, which year they found as a matter of fact. But if you would look, my lord, at the said judgment, which can be found at page 782 of the brief. Now, the page 700, the first page, second page, only deal with a brief history of the case at the trial stage. But what I would say is the important part, my lord, is found at page 787. This is the second paragraph, my lord. Their lordship said, all the issues raised in ground one relate to the appreciation of the factual evidence by the learned trial judge. They go on to state that it is tried law that an appellate court would only intervene in such circumstance if the decision reached by the trial court is so unreasonable that no jury of fact, etc. And they finish the paragraph by saying that in itself would have been sufficient to dispose of the appeal. But then they add, but there is more, and they go on to show how the appellant has not been able to prove that there has been any interruption in the possession of the respondent number one. Hence, and then on the paragraph that follows, the last paragraph, it starts off with this sentence. On the other hand, there is the evidence of the first respondent and his witnesses. Your lordships are fully aware that the evidence at trial stage was that the respondent number one deponed to the effect that he has been occupying the land since 61. The mere fact that the Court of Appeal made that reference shows that they are in agreement, that they agree as to the fact that respondent number one's version is to be preferred. Of course, if you look at page 788, the first paragraph whereby my learned friend highlights the last sentence, which shows that the first respondent was occupying the property prescribed by him at least in 1967. If you would look at the paragraph prior to that and you read that paragraph in context, the fact, it is my submission that the Court of Appeal agreed with the trial judge that the starting point for the acquisitive prescription was 1961. The more so that the conclusion of this appeal was that it was dismissed on all grounds. So if they had found that there was a doubt that whether 61 or 67, if they had favored 67, they would have computed the time, because we have to bear in mind that the affidavit of prescription of respondent number one is dated 12th of January 1995. So they would have calculated the figure, and they would, as my learned senior counsel for the appellant stated, that he would have fell short by 2 years. They did not. They set aside this appeal, and as a result of that, if we read the whole of the documents together, the paragraphs, sorry, my lord, I would submit that they have stated, they have come to the conclusion that it's 1961 that should be taken into account and not 1967. Now, there was an argument made by my learned senior counsel regarding the fact that the respondent number one was a co-owner, and that as a result of that, he should show something more. It would be my submission that regarding the showing something more, the evidence on record current in this in the Hurhangee case shows that the appellant was in occupation of the land. The co-owners are never mentioned at any point in time by the appellant. In fact, his evidence is, I lived on the property and I built my house in the middle of it. If someone was coming in, I would have seen them. Because this is regarding the Dr. Sigobin, where he says that he's never seen Dr. Sigobin. So if we take that part of the evidence, my lords, and we apply it here, we will see, it would be my submission that as a co-owner, he's done something more. He was occupying the land completely. There is no evidence on either side, whether respondents or appellant, that any other person interfered, save and except for that 1982 Rita Bere case, which I've dealt with initially. So his possession was in full, and he used it as an owner in all the capacity that he could as an owner. That is backed up in part, I agree, by the SIFP, which deals with the 1981 period till 1995 period. But before that, it is confirmed by his own witness, Mr. Mohanlal Ragua, who gave evidence to the effect that since 1961 or 62, he says, because he says it's after Cyclone Carol, that the respondent started living in that property. And he confirms at the end of the examination in chief that the respondents, plural, are still living in the property as at the date of the date of his appearance in court. So,
Mr. Chung, when the text talks about requiring something more
yes.
in respect of prescription against a co-owner, is it not envisaging that someone is the person seeking to claim prescription is a co-owner and is seeking to oust his co-owners? So, for example, that if Mrs. Bessoni's siblings or family were able to assert co-ownership, then the respondent's family would have to show something more as against them than maybe the mere occupation, because you could occupy in the capacity of co-owner without ousting a co-owner's title. As far as Dr. Sigelman is concerned, he is not a co-owner at all. I mean, he is someone who would have had a rival title to disputed land. So the co-ownership point doesn't really address Mrs. Hurhangee's claim at all.
Yes, I was going on the issue of co-owner because learned senior counsel for the appellant did state that because of the issue of the plot lot number 1, where the Bisuni were, they were co-owner, he had to show something more. But yes, I agree regarding Dr. Sigobin. This is not the co-owner would not come into play on that, but the fact that he had prescribed, because at the end of the day, what respondent number 1 has done is prescribe part of lot number 1 belonging to the Bisuni and part of plot number 2, resulting in the prescription of 11 arpents and 13 purchase, I think. So this is why the prescription must be taken as a whole in this case, because he's taken the lot number 1 and part of lot number 2. This is the point I was trying to come across. So if the lot number 1 is safe in between comma from the co-owners, then in the same way, lot number 2, the prescription should apply. And this is the point I was trying to drive across, my lord.
But this board can make no ruling as to the status of the respondent's family's possession as against the Bessoni co-owners.
Yes, of course. Yes, of course. But the mere fact that the title, the affidavit of prescription is in lot number 1 and in lot number 2 means that if ever the board were to decide one way or the other, it would affect both sets of litigants, I would call them.
Thank you.
Okay. Also, my lord, as I've stated in the written case of the respondents, a lot of the facts that this appeal, in a sense, deal with the interpretation of fact by the judge at first instance. I would submit that this board should be very wary of interfering in such sorts of decision in the finding of facts, because the board does not have the advantage of having had the appellant or the proxy of the appellant testify, because the appellant never actually testified. the respondent number one and all the other witnesses. This is why, because it is a matter of appreciation of the courts, I believe that it would be very difficult for this board to adjudicate on certain facts. Now, there is...
Mr. Chung, the point may go further. I mean, if you are correct in the passages in the appellate court's judgment, that in fact they were agreeing with the findings of fact of the judge at first instance, then we have concurrent findings of fact, and it is the practice of the board only in very exceptional circumstances to go behind concurrent findings of fact.
All right. Now, my lord, I'm about to make one submission which has just crossed my mind because Dalloz is still open in front of me. And it may sound rather strange at first, but if your lordships would allow me to finish this point, then I would be very grateful on that. Now, if the respondents were to accept the point of the learned senior counsel for the appellant that his possession could only start since 1967, and therefore that they are short of 2 years, my submission would be actually that if we go along that line, I'm not saying that submission is correct because we're stating all along that it's been since 1961. But since 1995, the 12th of January 1995, till the case has been lodged, I believe, page 10 of the brief, my lords, on the 19th of December 2000. Are your lordships with me?
Which page you mentioned? I'm so sorry.
Page 10, my lord. It's you will see the equivalent of paragraph 20 in the numbering, where it's stated under all legal reservation dated at Port Louis this 19th of December 2000 by the attorney for the appellant.
Yes.
All right. So since 12th of January 1995 till 19th of December 2000, where we're supposedly after that the defendant have been put on notice. I think it should be slightly later on, but notwithstanding that, we'll stick to the 2012, the December 2000. There's 5 years. Are we in agreement that there's around 5 years from January 1995 till December 2000? What he was still, the respondent number one was still in possession of the property by then. So if we move from 1967 till 1995, plus whatever time is missing, the respondent number one could have become owner by acquisitive prescription. I say that because it is by operation of law. What he wouldn't have is that he wouldn't have the instrumentum, he wouldn't have a document to show sale. If I could now direct your lordships to Répertoire Dalloz yet again, page 1242, I'm sorry, my lords, paragraph 156. Are your lordships with me? Yes. I will read paragraph 156. Effet acquisitif. Mais l'usurpation a cet autre effet de rendre propriétaire un possesseur qui ne l'était pas initialement. Elle joue alors pleinement son rôle de mode légal d'acquisition de la propriété le mécanisme investit le possesseur d'un nouveau titre, d'un titre nouveau, qui fonde son droit et qu'il peut, sans même être publié, opposer au tiers. That means by operation of law, if we are to take the version of the appellant that only since 1967 can the time run, between 95 and 2000, the period of 2 years has lapsed, has gone through, because the defendants were still in possession of the property in lite. I read further at paragraph 157, acte de notoriété. Toutefois, bien que l'usurpation confère un titre juridique au possesseur, that he has title by operation of the law, elle ne lui offre pas de titre matériel. Therefore, he doesn't have the title deed or the paper for it. But if we are to follow this line of argument, having established that in 1982 the interruption did not actually occur because the case has been set aside, 67 till 95, 28 odd years, 95 till 2000, till the lodging of this current case, means that they were still in possession, because this is not a denied fact, I believe. So by operation of law, the respondents would have become, sometimes in 96, 97, 98, would have become owners anyway by operation of law. They wouldn't have title to it, and they wouldn't have the paperwork for it. So hence, this application before this board might in somewhere somehow be some sort of academic judgment, if the board were to follow this argument.
That would depend, would it not, if there were findings of fact,
yes,
in the courts below, that the first respondent remained in occupation after 1995.
Then let me just try to see if we can find the judgment at first instance, where if there is anything
The plaint in this case, Mr. Chung, was to have the affidavit of prescription in effect set aside, wasn't it?
Yes, yes.
I mean, it wasn't addressing any fallback case, that even if that affidavit of prescription was invalid, nevertheless, by that stage, the respondent would be entitled to get a new prescription and carry out a new division in kind at a later date.
I agree with your lordship on that, because at that point in time, the respondent believed that he had legally, properly acquired the property via the affidavit of prescription. But the point I'm saying is that if we take 1967 as a point, because you will see that the respondents only sued for counterclaim of damages, which this part was set aside purely and simply by the learned judge. So this is the point I have tried to make regarding this. I haven't been able to find it in the judgment, my lord. So there is yes, the last issue that the your lordships asked me was there a duty on the court to explore if I haven't been able to note it down properly, my lord.
You may recall that Mr. Ramburn referred us to a passage which suggested that you know, whatever the parties put before the court could itself inquire into the quality of the possession. I'm just looking at notes to see if I can find
That is paragraph. I'm sorry, my lord. That is paragraph 30, I believe, of the Repertoire d'Arleuse 1205.
Thank you.
Is that the one your lordship is referring to?
Yes, it falls to the judges who are looking at the question of the UKPC to characterize the possession.
Yes.
What is the nature of that that obligation, if it is an obligation on the court?
I'm not following your lordship. I'm sorry. Does your lordship, is the question of your lordship to the effect that the duty should take a specific format, or the phraseology used in a judgment should there should be some sort of formatting to it? I'm unsure of the width of the question, my lord.
Yes. Well, it seems to say that the judges have to characterize the possession. Does that mean that if the party on whom the burden is placed to undermine the prescriptive possession doesn't advance an argument which he or she could advance against the prescriptive possession, it is the court of its own motion to look at the facts and characterize the possession, perhaps adopting an argument that was not put before them?
Could I perhaps help with a reference? Page 1143 in the bundle is the passage from the Camlerville case on which Mr. Ramburn founded.
Yes.
For that proposition.
Thank you, my lord.
Yes.
Well, I'm just going to read it out. Les juges du fond, that is the judge at first instance, jouissent d'un pouvoir souverain pour apprécier les circonstances de chaque espèce, la nature, etc. So it was down to the appreciation of the judge, it seems to suggest from that wording, to les vices ou absence de vices de cette possession. So if I was to submit an answer to that, that would be that the judge has to appreciate the evidence. If the evidence falls short for the, let's say, the plaintiff, they can firstly non-suit. If it doesn't fall short, it falls short by a mile, then they should just purely and simply set aside the demand, because in our law, I suspect in most jurisdictions, it is for the plaintiff to prove his or her case. So once you adduce evidence or you fail to adduce any sort of evidence, then the judge can only look at what's on record and say the demands are X and the evidence is Y, so decision either non-suit, dismiss, or plaintiff wins the day. So I'm not too sure that the judge will have to go into such an extent as to characterize each and every aspect of it, because from the reading of this section, the word I would highlight is apprécier, whether the circumstances, existence, possession, vice ou l'absence de vice, etc. So it's to the appreciation of the judge. He doesn't formulate as such the wording seems to suggest that he doesn't come into the arena to formulate some sort of argument in or against any party. He merely appreciates, to the extent legally bound by law, to do so. That would be my submission on that point, my lord.
Thank you.
Just, if I could just wrap up, then I would submit that this appeal should be dismissed.
Well,
Because,
Mr. Chung, before you do that, you may recall that I asked that you address the board on the nature of precarious possession, and also on the question of whether the judge in Camlerville at 11:49 was correct in his treatment of the animus domini. If you want to have the short adjournment over lunch to think about that, I am very happy that we can adjourn now and let you do that. But I think the board would greatly appreciate your assistance on those two matters.
Yes, my lord, if your lordship would be kind enough to grant me some time over lunch, I can try to formulate a submission on that, my lords.
Yes, unless there are any other questions from the board that don't appear to be, we will adjourn now and resume at 2 o'clock UK time.
Thank you, my lord.
Thank you very much.